possible circumstances. I work in a recording studio. I don't know what people do. If I accidentally touch it or any of that, it's not me using it. I will not use that drug.
Okay.
The most I've ever done.
You still carrying around a drug patch?
Yes, sir.
Uh-huh. How often do they collect the drug patch and test?
See, in the beginning, they didn't test it on the.
Pause right there. This isn't some casual stick. A drug patch is like a wearable lab test. Continuously monitors drug use through sweat. So when the judge asks about it, he's basically saying, we've got eyes on you 24/7.
How long? I'm just asking.
I honestly don't know, sir.
Well, I mean, don't they take the patch off of you?
Yes, sir. Well, I get
Don't you know when that happens, or are you
Yes, sir.
asleep?
I thought you were asking me when they tested.
No, I'm just asking.
Every 2 weeks.
Every 2 weeks. Okay.
Yes, sir.
And what have been the results of those?
6 positives in a row? That's not a fluke, folks. In court, 1 failed test can trigger consequences, but 6. At that point, the judge isn't buying excuses, and the science is doing all the talking.
It's all my levels have been going down.
You're fine, Scott. You sure? Yeah.
What are the results of those?
I'm not 100% positive, sir.
Nobody's told you about them?
They just tell me the levels have been going down.
Really?
Been going up.
Don, do you know anything about the results of the?
I was furnished with a copy of this yesterday, which shows me that he's still testing positive, but the results have been going down. The most recent one did not show to the level that it was previously.
Yes. It doesn't matter.
I haven't been using any drugs.
I don't care what you have. You've got 6 positive tests here. The last one was a drug patch that was collected a week ago.
But I haven't been in 2 weeks.
I don't care what you are.
Yes, sir.
You're not,
I'm not.
on my watch, you don't test positive for drugs.
And here comes the classic courtroom defense. It wasn't me. It was a miracle. Judges hear this all the time. Question for you. Do you think someone can accidentally test positive for cocaine? Or is that just courtroom comedy?
You got six positive tests here for cocaine.
I can take the drug test right now.
Good for you. You failed the other
I
tests.
don't know how cocaine came up. I do not.
It must have been a mystical event, a miracle.
I'm so
But
serious.
this is science. You know how many? I wish I had $1 for everybody who says, "I know I'm testing positive. I don't know how that got in my system."
But I'll put my right hands on the Bible and swear.
You can write down. I've heard that one before. I swear to God, I know.
I stopped
I
smoking
know.
everything.
Every polygraph goes off in the city when you say that. No. Yeah. Just because levels go down, that's not. They're supposed to be 0. Nothing.
But
Not a hint.
sir.
You've been testing positive on cocaine now since, let's see,
That's what I'm saying.
since June,
I don't
buddy.
understand how I can test
I know.
for cocaine.
But I'm going to rely on science, not your
I
word.
understand.
Okay, all right,
I understand.
all right. What is this bond?
$30,000.
Yeah, your bond is revoked. You're going to go to jail. Sorry, the rules are the rules. First thing, don't commit a crime. Illegal possession of cocaine is a crime. It's in your
Don't
system.
possess it. Never touch
It's
it.
in your system. You're possessing it. You don't have to have it in your
Sir.
hand, sir. It's in your system. Don't interrupt the court when I'm trying to
Yes, sir.
talk. You're going to debate me?
No.
Really? You're testing positive on these tests 6 times in a row here. Every 2 weeks, 6 times. You're testing positive, and you're going to debate?
This is an important legal nugget. In many jurisdictions, if a drug is in your system, you are legally considered in possession. You don't need it in your pocket or hand. Your bloodstream is enough evidence.
It's not a debate.
No debate. I just want to tell you.
Shame on you.
Possible circumstances. I work in a recording studio. I don't know what people do. If I accidentally touch it or any of that, it's not me using it. I will not use that drug.
Okay.
The most I've ever done is smoke marijuana. So, and I don't even do that anymore.
Sorry. You've got cocaine in your system. How it gets in your system, I don't have to figure it out. I don't have to prove that. The tests that they're coming back are enough. You shouldn't be testing positive. Change jobs, if that's what it is. Do something else, but you've tested positive 6 times. No one does that. That's a rare event here. My God, I get 2,500 cases a year for 18 years. This is a rare event. And you can't attribute it to a miraculous event. It's not a miraculous event. It's It's science. Your bond is revoked.
Yes, sir.
You're in custody. Mr. Arline is present with his attorney, Mr. Rennick, and the state's attorney does. The defendant waive a formal reading, of the indictment and the arraignment. Can we proceed in summary?
Yes, Your Honor.
And just going on the
Prior convictions.
going on the first paragraph, Your Honor.
It's kind of getting a bargain deal here there, buddy. We go back to 2011, no? 2007.
Now we switch gears. Listen closely. Indictments can sound like a foreign language, even to people in the system. If a judge of 40 years calls one odd, you know it's not written for easy reading.
1994, 1992, 33 years of felonies, including 3 prior burglary convictions of habitations. And so we have another burglary of a habitation. 25 CR 107 is now called, and Mr. Arline is present again with his attorney, Mr. Rennick. In summary, paragraph 1, this is very confusing, the worded indictment. I've done this for 40 years, and this one is an odd one. Okay. It alleges in the indictment that on or about January 17th, 2025, Jefferson County, Texas, you committed the second-degree felony of burglary of a habitation. Paragraph 1 states you committed the burglary without the effective consent of Rebecca Gaspard, the owner, with intent to commit theft and assault. And paragraph 2 states you committed burglary of a habitation. You understand what you're charged with that confusion. So it's a second-degree felony. If convicted, again, you're facing no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand, sir? Yes. An agreement's been reached. You would be pleading guilty, sentenced to 10 years in prison. Is that your understanding of the agreement as well? Another case, 25 CCR 440, would be dismissed as consideration in this agreement. If I follow this agreement, you have no right of appeal. Do you understand?
Yes.
How do you plead to this case, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is, on your own free will and because you are guilty?
Yes.
I can show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily, understand it, discuss it with your attorney? Are the contents true and correct?
Yes.
State's Exhibit 1,
No objection.
tendered into evidence without objection, is admitted. Among other things, the states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. The indictment's read to you, and you've read it. You are guilty of the crime charged and any lesser included offenses.
And just like that, 10 years locked in. No jury trial, no appeal, because of the plea deal. This shows how quickly courtroom momentum shifts. One moment you're bargaining, the next your fate is sealed.
You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is way.
Yes, Your Honor.
I'm going to follow this agreement then, sir, and make the following findings: that you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this second-degree felony of burglary of a habitation. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. Do you understand what has happened today, sir?
Yes.
All right. You're going to be taken into custody, as you understand. Anything else?
No, Your Honor.
All right. That is all on this case.